the partners, the newest partner over here at Altitude. And today we're going to be talking about collections, receiverships, and foreclosures. What's the difference and why do you care? You may not care at the end of the webinar either, but at least you'll have a basis for doing so. So on the screen, couple housekeeping things. One, you should see the PowerPoint presentation right in the center of your screen, and it should take up most of it. On the bottom right-hand side is me, that's your presenter, and then the left-hand side should have your chat icon. You could type any questions you have there, and then we'll try to get to them at the end of the webinar. CMCA credits are automatically generated once the webinar hosting site provides attendance confirmation report. That is sent via email within 48 hours following the webinar. Much like your flights and plane tickets, those are not transferable either. You can email education@altitude.law, call Sean Sanders directly at 303-991-2076 if you have any questions about those certificates. The webinar will be recorded and then it'll be up on the ACE YouTube channel in about 24 hours, sometimes 48 hours. So with all that being said, housekeeping is over and we can start the webinar. Let's get started. We're first going to talk about collection. So the basics of collection is you need to have a collection policy and it needs to be compliant. What does that mean? It means that under Colorado state law, you have to have for example, the payment plan information or there's a number of other items that you must have in your collection policy to bring it compliant, and it has to be in line with your governing documents. If you do not have a compliant collection policy, we're not going to be able to open the file because down the road, if we get challenged on that, it's going to be an issue and result in a lot of money that the association is probably going to have to pay out. So we need the collection policy, we need a zero balance ledger, the delinquency notices, including the HB 1276 letter, which is that payment plan letter, and then it must be sent to the correct owners and correct addresses. The delinquency notices must be. So let's go back. The zero balance ledger, I need a ledger that at some point goes down to a zero balance. So if in March of 2021, it shows $500, but then they paid it off and we're now at a zero balance in April of 2021, I can start with that. But if you have a ledger where there's $6,000 coming from 2019 and we have nothing to go back showing what those charges were, it's going to be an issue later down the road again, which is where we find most of our issues if it's challenged in court. So what you will find is we're going to come back to you and say, hey, do you have a zero balance ledger? And if not, we may recommend that the board either write it off depending on the amount, or we will give the board a heads up, or you guys as CAM saying, hey, this might be an issue proving it down the road. And so you may have to write it off then. The delinquency notices, your collection policy or your governing documents, again, we want you to have the compliant collection policy, should specify the notices that need to be sent out pursuant to your collection process. So when you do decide to proceed against an owner, we're going to want to have anywhere from that initial notice, whether it's an invoice or just a statement that says you are behind, all the way up to what is referred to as the HB 1276 letter, which is the letter that tells the owners that a payment plan is available and who to contact for that information and so on and so forth. We have a lot of boards who are struggling, particularly over the last 2 years due to COVID with collection. And so the one thing that we tell the board is follow the collection policy because you have to treat everyone fairly and equally. What that means is if the board is willing to write off or waive late fees and interest for one owner, then the board should be prepared to do that for other owners as well, because otherwise they'll be accused of selective enforcement. So we remind the board you have a fiduciary duty to collect assessments. That is how the entire association runs. That's really the lifeblood of the association. And part of that is sending the delinquency notices to all the owners and to follow that collection policy and treating everyone fairly across the board. And then the last thing is those notices don't do any good if you don't send them to the correct owners and the correct addresses. So if you are sending the letters to only one owner and there's 2 or 3 owners on the property, the association in nearly all cases has the option of proceeding with collection against only one owner. But the problem is that in the future, again, if the board decides to do something like foreclose, so 2 years from now or next month or whenever, the foreclosure department, because of the foreclosure process, is going to need those letters to go to anyone who had an interest in the property who is listed as an owner. So we may as well start out from the beginning here. The addresses, we always want to send it to the property address if that's the owner's mailing address. If the owner has provided an offsite address to you, then certainly that can be used, but you might have questions, particularly coming from altitude, but certainly your attorney is saying, hey, where did you get this address? So the reason being is because if it's challenged by the owner that they didn't get mail, that's something we hear a lot, they didn't receive the notices, etc., then we at least have something showing, well, owner, this is where you told us to send the notices. So if that issue arises, we have the basis there. Okay, so the compliant collection policy, it must state when the assessments are due and delinquent, how much you're charging for late fees, interest, return check fees. The return check fee has to be the $20 pursuant to Colorado statute. You can't charge, I've seen some with 50 and some with 30, and none of that. It has to all be compliant with state law. The circumstances in terms of payment plans and offering a minimum of at least 6 months on your payment plan. If you have an association with a collection policy that does not have this information, then we're going to review it and come back to you and say, hey, this is what we're missing. We need a compliant policy. Now, frequently, we will have some boards who had a compliant policy and then changed 1 or 2 things. The problem is sometimes they change the 1 or 2 things that make the policy then non-compliant again. So it's a pain, I get it. But if we come back, if your attorney comes back and says, hey, this policy is not compliant and this is why, then we need to talk about it. And we may need to restart the delinquency process depending on the policy. Similarly, if your collection policy says it's charging 21% interest and the association's governing documents only allow for 8% interest, that's going to be another problem. So while the policy may be compliant with state law in that situation, it also must at least be compliant with the governing documents of the association as well, assuming that they're still good to go. Again, all the notices must go out before the file can be opened. So the big one is the one we refer to as the delinquency notice, the HB 1276. Why is this important? HB stands for House Bill 1276 was the number of the House bill. That's just fancy lawyer terms for, hey, this is a law now. The delinquency notice, so that letter that you send, which should be required by your collection policy, but also is the most important one that we can get, must state what the total is and then an accounting of it. So either the ledger needs to be attached and then showing how that balance is calculated, or you need to have a breakdown on there that says assessments, late fees, interest, fines, whatever else is on there, the breakdown of the balance so that the owner knows where that total is coming from, what the accounting is. The letter must give the owner 30 days to cure before it can be turned over. So 30 days for the owner to pay the balance or enter into that required payment plan. And then the name and contact information of the person, the owner, must contact to enter into that or to obtain additional information. It cannot just say contact the association. It has to say contact Bob at this phone number and email, or contact the manager and the manager's name and phone number, email, etc. And then what legal remedies are available if they don't pay. So it usually will say something to the effect of that failure to cure can result in being turned over, a lien being filed against your property, being turned over to a collection agency or attorney's office, receivership, foreclosure, that type of thing. With regard to foreclosure, anytime we're looking at foreclosure, and I put this in on this slide because sometimes when a file is turned over to us for collection, the board wants to immediately proceed to foreclosure. And I'll get to more foreclosure down the line here. But the foreclosure, the balance has to be equal to at least 6 months worth of assessments. And then the board has to vote on that on an individual basis. But again, if you don't have that delinquency notice, we're going to come back and say, hey, you have to restart the process. And that's really frustrating for everybody. So, and then accelerating assessments. If the association has an acceleration clause in their documents that authorizes them to accelerate the assessments, so to bring due all of the assessments that would be incurred, let's say, over the next year, then the association could certainly look at doing that. And sometimes that's a really great idea, particularly if we have an association who maybe has low monthly assessments or who has low quarterly assessments, or it's just an annual assessment. If the board can accelerate those, then instead of the owner only owing, let's say they're 3 months behind, we can go ahead and add those future assessments onto the ledger and then collect them all at once. The benefit of that to the association is that if and when the owner pays, I say if because sometimes we have to garnish or forcibly obtain the monies, the owner would then be caught up a little further than they would be if we were only collecting for that certain time. So that's always an option. So what do we do when the file's turned over to collection? In general, and specifically over here at Altitude. And by the way, I love this cartoon because I'd like to be sorry and move on whenever I owe money as well. So at any rate, when the file's turned over, we're going to either review a lien if you're a type of management company that files its own liens, or we're going to record the lien for you if you have asked us to do it. And then we're going to send that demand letter out. The demand letter, even though the owner has presumably received the delinquency notices that the association is required to send, we as debt collectors are required to send a demand letter, and the owner has 30 days to respond to that demand letter. Now, what has happened recently, back in November, is that a law was passed saying, well, sure, it's 30 days that you have to give the owner to respond, but we need to include holidays, and you have to account for these days, and then you have to add so much on either side for mailing the demand letter. And so what happens is that it ends up being probably closer to around like 38 to 40 days, give or take, that the owner has to respond because you add all those other dates in there. The demand letter is going to tell the owner that we're collecting on behalf of the association's name, the breakdown of the balance due, and then it's going to also tell the owner that they can contact our office. And actually the new demand letters that are now required almost look like a statement where it has the option of checking the box of you dispute it, you don't dispute it, you enclose payment in full, etc. The owner does. So we're going to send the demand letter. If there's no response within that time frame, then we're going to evaluate for a lawsuit. If it's a lower balance, we're probably going to send a follow-up demand letter. If it's a high balance, we can certainly proceed to lawsuit. And then certainly if the owner contacts us at any point in there, we can provide them with payment options. Most of the associations we work with allow payment plans. I will say at this stage, while I recommend doing payment plans because it's a way to get the owner bringing the money in, and oftentimes they don't have the full balance due, there is no requirement once the file's turned over that the association enter into a payment plan. That 6-month required payment plan is purely before the file is turned over to our office. So once it's turned over to our office and it's in the legal system, ultimately, the association can offer payment plans. It can choose not to. It can say, well, we'll only authorize payment plans up to a certain amount, a certain length in time, etc. If that is something your association wants to do, then you should just let us know. And then that way we kind of have an eye on that while the payment plans are coming through our office. The difference between turning over to a collection agency and an attorney, there's a couple differences. This is a question that came up on the side here. So collection agencies, there's kind of a variety of them. And I'll tell you that law firms that are collecting for creditors, such as an association, is also considered a collection agency. So even though it's a law firm and we're going to be billing and we're representing our client, we're still considered a collection agency under the Fair Debt Collection Practices Act. But one of the biggest differences I see is sometimes a collection agency, the collection agencies oftentimes will buy a debt, so they'll pay off whatever the creditor is they're collecting for and then collect the debt on their own. Or they'll just maybe they'll do only phone calls for the price that's paying to try to get the money in. They usually don't have an attorney on staff to actually move forward with the lawsuit. So if it was just with the collection agency, they would then turn it over to an attorney later. We do have files sometimes that go from a collection agency to us. And while I don't see anything wrong with that in general, what happens oftentimes is all of those fees that the collection agency may have charged are still charged to the owner. And then, of course, now the owner's in our office and we add our fees. And so it kind of makes a bad situation worse, but certainly an option and one that is utilized. Okay, next slide. So this is kind of a general overview of what happens with a file if it proceeds to a lawsuit, and where we go from there. And I get a lot of these questions from both managers and boards going, well, okay, it says you sent a demand letter, what happens? Or it says there's a return, what does that mean? So this is just a flow chart. You're welcome to show your boards. We do the demand letter. Like I said, if the owner reaches out to do a payment plan or something like that, then the file almost goes into a holding pattern. It's not on hold, but because they're in a payment plan, we're not incurring additional fees as long as they're staying current, versus if they don't contact us at all or they refuse to pay, then we're going to incur more fees because we're moving the file forward. So on this, you'll see the demand letter. If there's no response, the balance is high enough to sue, we're going to draft a summons and complaint, which is the lawsuit, and we're going to send it out for service. What that means is we're going to have either a process server or sometimes the sheriff go out and try to find the owner to serve them with the paperwork. Serving them is the official legal word for giving them the documents and then signing an affidavit that's filed with the court saying that, yes, I did serve this owner with this paperwork. There are some ins and outs to service depending on what is being served. Sometimes we can serve the documents to a spouse for the owner, or to another adult that's living in the home who's over 18. There's also certain types of documents that cannot be served on anyone but the owner. At any rate, once there is service, and that can take a long time, because if an owner is avoiding service, if they, maybe all of us, all of the association, all of the managers thought the owner was living in state and it turns out they've recently moved, it may take a while to track them down. So sometimes that can delay the process. At any rate, if they're served, they then have what's called a return date. And the return date that's what you're going to see on the status report. The return date just means that's the initial court appearance by which the owner can either do nothing, in which case we're going to request default judgment, or file an answer. And the answer, again, is just the legal word for the owner's response to the lawsuit. We see a variety of answers. Some of the answers assert defenses that are allowed under the law, like they already paid it, or they don't owe it, or their payments aren't credited, or they're no longer the owner. And some of the answers, probably the more frequent answers, say, I can't afford to pay it. And that is terribly unfortunate, and it happens to everyone at some point, but it's not a legal defense. And so what happens is, more often than not, if we were to proceed with judgment, we may get it. At any rate, If the owner does not file an answer, we're going to request default judgment on behalf of the association. And then we're going to move into collecting from the assets. And that's going to be, we're sending letters to the owners. We may, with the owner's permission, be emailing them. We may give them a phone call. Certainly, if we're not getting any response, then we're going to proceed to a garnishment, which will either be a bank garnishment or a wage garnishment, or they'll voluntarily pay and we'll move forward from there. Successful obviously equals money. If we are not successful, the next step in our lawsuit is going to send out what we refer to colloquially as ROGs. The long word is interrogatories. That's a fancy word for saying, hey, what are your assets? The court will order the debtor to complete those asset questions. Debtors don't like to complete the asset questions. There is no owner that likes to A, be sued, B, get a judgment against them, and then C, have to fill out a form that tells me where their banking and employment information is. But there's a court order that says they have to. If they fill out the interrogatories, we will proceed with garnishing because it just gives us more of an idea of what they have and where we can garnish. Again, this is all assuming they're not going to pay voluntarily. If they don't fill it out, then we will go to what is called a contempt hearing. All of these parts of what I'm talking about involve serving the owner with the documents. So again, there might be a delay there. Why am I telling you that? Because you're going to have boards that say, I don't understand why this is taking so long. This is part of it because there's all kinds of rules. The interrogatories, if they don't fill them out, we go to the court hearing. If they show up, judge can usually get them to fill it out. If they don't show up, we can issue a bench warrant, and then we wait to see if they're picked up, and we start from there. Going back to the answer filed, if they do file an answer, the court is going to order more than likely mediation. A lot of our counties are mandatory mediation, and then certainly a pretrial and a trial if we don't resolve it. At a mediation, we sit down with a third-party mediator who is basically trying to bring the parties to the table to work out a deal that both parties are happy with or equally unhappy with. So you will see us reaching out to you or the board saying, hey, what kind of settlement can we look at? Usually we're looking at things like we're recommending waiving interest, sometimes late fees. Sometimes late fees are a hard cost, but it's not usually the entire late fee. So there might be some soft costs in there that we can waive. Certainly as the attorney, I might waive some of my fees to aid in resolution. If we resolve at mediation, great. Otherwise, we're going to pretrial. Pretrial is just showing up to court and saying, hey, judge, we're still on for trial. How many witnesses do we have? What issues do we think? How long do we think the trial is going to be? Again, we can resolve at any point in through here, but that's kind of up to the owner and then certainly the board if the board is willing to compromise at any point. And then we'll go to trial. Trial is where we are going to need the manager or the account tech to show up and testify. Trial usually takes about 2 hours, depending on where we're at. If we're in a county that's further away, you can add travel time onto that. If we win at trial, we get judgment. We're going right back over to the collecting from assets, getting the owner into a payment plan, bank garnishment, wage garns. If we lose at trial, well, then we're having some hard conversations because, of course, the clients want to know, why did you lose a trial and what happened? Why did the judge rule against us? Usually we resolve most of these cases before they go to trial, but sometimes it happens. So there is a question about, do the police actively pursue the warrant? They don't. So what they do is, because it's not really a criminal warrant. I mean, they didn't show up and they didn't comply with the court order, but they're not going to be picked up like they would if it were, let's say, a felony warrant, right? So oftentimes what happens on those warrants is that people get pulled over for like a traffic infraction, like they're speeding, or they're on the side of the road because their car broke down and for whatever reason their name is ran, and then they get picked up on the warrant. Some counties will allow us to request a cash bail to be posted, which then goes to the association because they have judgment. Other counties, especially right now with COVID, will do what's called a PR bond, which is a personal recognizance bond. It's basically the owner signing a document promising to come to court. It's not as effective as cash bail, but the point of all that and the warrant is to try to get the owner to fill out the interrogatory questions. The interrogatories are going to talk about, like I said, wages, where they're banking, if they're collecting rent. There are some other things that they will put on there oftentimes that the association has the ability of going after, but it's much more difficult. So like a vehicle, like the association could go after a vehicle, but then the association is going to have to figure out how to liquidate the vehicle in order to get the cash or stocks or bonds or collections, etc. So it's usually a smoother and certainly a more efficient process to just do the wages or the bank. Okay, so let's say we have judgment and we're going to garnish. This little guy's shaking all the money out here. So right now, the court allows us to garnish up to 25% of the net disposable income. The continuing garnishment, that's just a wage garnishment. It is only good for so many months, for 6 months. If there's Social Security income or child support income, then that can affect certain types of garnishments. It's not really a job either, but you'll see owners put that on there as income. If we get the employer garnishment, first the court orders it, we then serve the employer, and then the employer has 40 days to respond. Once that time has passed, we're assuming they respond, then they'll start sending in the money. And again, it lasts 6 months. The bank levy is the next type of garnishment, and the bank levy is kind of a one and done. So what I mean by that is, whereas the wage garnishment will last over 6 months, the bank levy, it's ordered by the court. We send it to the bank. The bank then has to respond and seize the money from the defendant's account. And then we have to serve the defendant, the owner. But if there's no money in the account, if we hit at the end of the month when there's no payday, let's say, we might not get anything, versus if we hit it at the right time, we might get the full paycheck. One of the issues with the bank levy is we then have to turn around and serve the owner. And again, if we're having problems serving the owner, that can delay it for quite a few months. The important thing about this bank levy also is that right now, I'm sure you all remember when COVID was, all of the kind of legislation was happening about not allowing garnishments unless we send certain notices, and then bank garnishments, the exemption, the owner could keep up to $4,000 in the account under COVID, and then we were only able to garnish above and beyond that amount. Well, not many owners have $4,000 in the account. There's legislation that is kind of circling around Colorado right now that would look at making that $4,000 exemption permanent. So I don't know what's going to happen with that. I don't know if that's going to go. It'll be interesting to see because it is a larger amount. So we'll wait and see what happens. I'm sure we'll be updating it on the blog and newsletters as it goes. So some collection problems we get into as we go. If someone's self-employed, it's difficult to garnish them because they're the ones filling out the form. And usually if they're self-employed, it's going to be like a much smaller business as opposed to a corporation. And so the funds just aren't there. Certainly if someone is in the military, can we still sue them? Yeah, but it's a lot of hoops to jump through for the association, and it can be costly depending on where the owner is at in their active military deployment. So it can result in the court ordering that the association kind of provide an attorney for the defendant in a way, because we have to comply with the Civil Service Members Relief Act. So military, you'll see more letters go out on military before the lawsuit if they're active military, because we're trying to keep those costs down. Banks, if a bank owns the property, so the property went through foreclosure a while ago and then the bank ended up owning it, that's always difficult to collect from because they're big and they don't respond. So it might take a while. LLCs, limited liability companies, there's a shield there protecting assets. And so sometimes the assets are harder to get through or to. Judgment proof, what does that mean? It means an owner has income that is not garnishable. So an owner that's, again, that child support that we mentioned earlier, Social Security, something like that. If the type of income is such that the law does not allow us to garnish it, then we're probably going to refer it to foreclosure depending on the amount of the debt, because that's going to be the association's really one of the few options if the owner isn't paying voluntarily. If there is that foreclosure by another lien holder pending, that can result in some issues because there's just different timelines we have to adhere to, and there's different options that we may or may not recommend based on that pending foreclosure, like receivership, which I'll get to shortly. And then certainly if an owner files bankruptcy. Bankruptcy, it puts an automatic hold on any collection action, including telephone calls, including letters, including filing that notice of lien. So then we have to work through the bankruptcy system, filing proofs of claim or objecting to the bankruptcy plan. There's a lot in it. So we work around it, but you will see, again, all of these collection problems will cause delays and they cost money. And it's really difficult when we have clients who are already waiting on money to come in to then be paying out trying to collect it. It's a frustrating process. I, of course, can, if you know me, can wax on and on about bankruptcy, but I promise I won't right now. At any stage in any of this collection process, we can review a file or recommend a file for foreclosure or receivership. And you might see that. You might see a file that says on the status report, we've asked our foreclosure department to take a look at it. And our foreclosure department is then going to, they do a number of things, but they're basically going to pull documents, look at the file as a whole and say, is this a property we would recommend foreclosing on? And they might not. They might say there's not enough equity in it, or that HB 1276 letter was only sent to one owner or something like that. But nonetheless, you may get a letter that says, hey, we are or are not recommending this property for foreclosure. And then it's up to the board to decide whether or not they should move forward with it. And some boards will say, yeah, great, we're tired and we want to collect and it's a large balance. And other boards will say, I know that might be one of the few options we have left, but I don't want to foreclose on my elderly neighbor. So it's a difficult situation. Receiverships. So when we talk about receiverships, it's the court-ordered appointment of basically a rental agent. So we have a receiver that we work with, and there's a couple different ones floating around the area, but we work with Ryan Gulick is one of the receivers we work with. And so basically we look at the property and we say, okay, is this a good property for receivership? And if it is, then we do the following. So we're going to say, is the property vacant or does it have a tenant in it? How do we know that? How do we know a property is not owner occupied? Well, maybe our process server went out to serve the lawsuit and is reporting that the property is clearly vacant and has no life and the yard is unkempt and no one's clearly been on it in months. Maybe the board is telling us the property is vacant. Maybe the owner, we've had to serve them out of state. We had to locate their address because they use the property as a rental home, or the owner is deceased. And so we will then look at a receivership to see whether or not that's going to be a good option for the board. So if we do a receivership, if the property is vacant or it already has tenants in it, we're going to file a motion with the court. That can be done either before we get judgment in a lawsuit or after, depending on the judge. Some judges want us to go through the entire process. Some judges say, great, let's do a receivership. And there are judges who will order the receivership even if we haven't been able to serve the owner. And you will see us use receivership a lot in those circumstances after numerous times of trying to serve the owner with a lawsuit. we will request a receivership because clearly the owner's nowhere to be found because we haven't been able to serve them, or they're really good at avoiding service. And then the judge may or may not order it. We have some counties that will order receiverships. Some counties won't, so we'll have to go to district court in those counties. But at any rate, we file the documents and then the court orders the receivership. Then the receiver goes to the property. He has the court order and he either says, hi, tenant, I'm the receiver. I've been court ordered to collect rent. You're going to start paying me. Or he goes out there and he looks at the property and says, what do I need to do to get this property up and running? And then he will find tenants for the property. He then provides regular updates to the association and the court, who will file reports with the court. And then he is paid hourly. So what happens is the receiver is going to collect the rent to pay his fees, and then is going to start sending it to the association until the association is made whole. So that's going to include any legal fees that are on the account, etc. This can be a really, really wonderful way to get someone's attention because it interrupts an owner's revenue stream. And as soon as those rental payments aren't coming, the owner's on the phone wondering where they are. The owner's then informed that there's a court order. Now, it's not like we haven't tried to inform them beforehand, but it's often this that really makes the difference. And then the owner suddenly starts making arrangements very quickly to take care of the balance. So factors to consider for receivership. One, is there a foreclosure pending? We can do a receivership even with a foreclosure pending, but we're going to want to make sure that we're not running up against that foreclosure. So if we have a foreclosure that's scheduled in April, we don't want to do a receivership now because there's not going to be enough time to install the receiver, then have the receiver install the tenants, collect enough rent money to make it all worthwhile before the foreclosure happens. But if the foreclosure, let's say, isn't set until next year, well, we have about 12 months. Certainly we can do it in that time frame. We're also going to look at whether it makes sense for the community. So if it's a low balance due, it probably doesn't make sense for the association because we're going to spend more on the receiver collecting than the actual balance. So we'd probably want to wait then to let the balance grow a little, see if the owner cures it. Rent for the community. If you're managing a community or you live in a community where the rent is very, very low, it might not make sense for a receivership, or we might do it, but it's going to take a much longer time than a community where an average rent is, let's say, $3,500 a month or $2,500 a month. That would pay out more quickly. And then the condition of the property. So while the receiver will go in and can bring the property up to the point where he could put a renter in, you want to make sure that it is a feasible decision for the board. So if it's a property and maybe the only issue is the lock on the door is broken and there's weeds in the yard, that's not going to cost too much. Receiver will take care of it. The board's still going to recoup their money. If the receiver goes into a property, though, once the court orders it and he's allowed to really scope it out and finds out that there's mold remediation that needs to be done, well, that's going to be very costly, and it's probably not something the association's going to want to pay out for. It wouldn't make sense. So all those are factors that we're going to look at, the ones we know about, and certainly the receiver as he sees the property. But then it might come up again where the receiver comes back and says, well, now I'm in the home. I don't know if you guys want to do this or not. Okay. Let's see. The other thing I wanted to mention about receivers is that a receiver, law firms and collection agencies are prohibited from discussing an account with persons that the owner has not authorized us to release the information to. And the receiver, because he does not fall under the Fair Debt Collection Practices Act, is not going to have those same problems. So the receiver will be able to speak to, you know, Tommy's girlfriend, because Tommy's not home, about what the process is and, hey, this is what we need to do to pay it off and get me out of your life, me the receiver, and of course me the attorney too. But at any rate, anything else about receivers that I can think of right now? I think that's it. We do have some issues that can come up with receivers. So there's the costliness of it. If let's say the owner did pass away, but in his will, he wanted the property to go to an heir and it's the heir residing in the property, then we might have an issue with whether or not we can collect from the heir who's residing in the property. So that's all things that the receiver is going to look at as well. So those can be issues that come up. I don't have very many of them though. So moving on to judicial foreclosure. So there's two ways it's going to go to foreclosure. One, the board says, no, I want to go to foreclosure right away. Maybe it's an owner that they've had numerous issues with, or we've had, a frequent flyer or 7 files in our office, or the balance is huge and the board just doesn't want to mess with it. Or maybe it's a business and estate or a trust. So an owner that's not your typical owner. I suppose the third option would be there's no assets to collect from. But at any rate, in any of those situations, we're going to look at judicial foreclosures. And I like Snoopy, so that's why he's on here. So there's 2 kinds of foreclosures you will see primarily. There's public trustee foreclosures, which you'll see done by the mortgage, the senior lien holder, the deed of trust. And then there's judicial foreclosures. And the judicial foreclosure, try to say that 5 times fast, is the one that the association is going to use. Why? Because the association, the nature of its relationship with a property and property owner in its association does not generally have an authorization to sell. So the association has to go through the judicial foreclosure process in order to obtain the court order allowing it to sell the property at a foreclosure sale versus, let's say, a mortgage company who probably already has that in their contract that if an owner's delinquent, they're authorized to sell off the property. So they can proceed through public trustee. So the judicial foreclosure, in order to do it, we need to make sure the balance is equal to or above 6 months worth of assessments. Now, maybe it's 8 months worth of assessments, but the assessments are only $100 a month. Well, you probably don't want your board to pay for a foreclosure for $800. Maybe you do, maybe if it's a frequent flyer, maybe if it's the only option, but more than likely you don't. So it has to be a minimum of 6 months worth of assessments. But again, we're going to want to look at the amount to make sure that cost benefit wise, it makes sense. And then the board must vote for each foreclosure. So what that means is the board can't sit there and say, we have 5 delinquent files. They've all been there 6 months. Let's foreclose. The board actually has to say, okay, property 233 West 3rd Street, do we want to foreclose? Property located at this address, do we want to foreclose? And then the board must sign a foreclosure resolution, must vote and then sign the resolution for each property, or must vote and record the resolution decision in the minutes. I like the foreclosure resolutions personally. I don't know if our foreclosure department, I know that they have handled both the resolution and the minute vote. I like the resolution because it's a piece of paper I can submit to the court, but either is fine. Keep in mind, though, that the collection policy must have been followed. So going back to what we were speaking about earlier with the association saying, hey, we're just going to proceed against the one owner for now, even though there's 2 owners on the property. If we get to this stage, or if the board decides it wants to foreclose, we're going to go back, our foreclosure department is, and say, I think that's great that you want to foreclose, but you're going to have to restart your collection process from the beginning following your policy because this letter was not sent to all the owners on the property. So it's better and it's certainly more efficient and less costly to get it all out of the way to begin with. Again, with foreclosure, 0 balance ledger, just like we were talking about earlier, and the compliant collection policy. I can't emphasize this enough. You have to follow the policy with regard to the notices, or you're going to have huge issues and it's going to be very expensive down the line, particularly if it is in the foreclosure action. So if you feel like, wow, those people over at my law firm keep asking us to do things and we just want to foreclose, this is why. It's because it's going to save money on the back end. All right, so when should foreclosure be considered? We've pretty much reviewed these. Certainly if it's a chronically delinquent account, If you have a large account balance, that judgment proof, so the owner who only has income that we cannot touch, the association cannot get to collect. And then, is it a property that has a lot of equity in it? And so part of that recommendation that we were discussing earlier, if we refer a property to foreclosure for a recommendation, is they're looking at the equity. And they're going to tell the association and our managers, there's a lot of equity in this property, it makes sense, or this property is worth $500,000, but there's 3 other mortgages on it, there's a master association, there's a tax lien, whatever. So kind of measuring the likelihood of what they're going to get out of it as the association when it forecloses. Benefits of foreclosure. And if you can't read this, it says your mortgage has a huff and puff clause, but it doesn't cover foreclosure. So the little pig, bummer. Benefits. It brings the hammer. That's like the easiest way to say it. Collection matters. You got to figure what all is in collection. I mean, we have medical bills, and you get collection agencies calling all the time, and you have maybe, I don't know, your cable that you didn't pay or whatever. Owners are getting all kinds of collection information. And if you have owners who are very with it, they're opening their mail, they're on top of it, they want to solve the problem, then collection works. But if you have owners who, I mean, as soon as they get caught up, they stop paying again. If you have owners who have been in our office 5 or 6 times, anything like that, the association having the right to foreclose is a huge boon to the association, because not all creditors have that option. You might have a car who threatens not a dealership, I'm sorry, the finance company threatening to repo a car, but there's not many people that can foreclose a mortgage, not many associations, entities. So it really kind of just brings this huge, like, oh my gosh, I'm going to lose my home if I don't take care of this, and kind of imparts the seriousness of a situation of being in an HOA. So it's a high rate of recovery. It's usually the full balance owed, because once it gets to foreclosure, it's no more, oh, we'll take $100 a month, and then maybe the owner falls behind, and then, okay, now we're going to sue, and et cetera. So it really, it's that one that, and it's pricey, but it's that one that the association wants to use to say, this is it. It sends a message to the community knowing that you have an association that does foreclose. It makes people sit up and notice. And then if you have an owner in any of these situations, or an owner that's not taking care of their property, the foreclosure is going to force a transfer of ownership if the owner doesn't cure the balance. So they might just let it go to an investor or someone else. Average time for a foreclosure. This is what I hear from our foreclosure department. If you ask why a foreclosure takes a long time, it's because it takes a long time. So if it's uncontested, so we file a foreclosure for the association and the owner says, fine, take my house, it's going to be probably an average of at least 9 months by the time we get through the process. But if it is contested, if the owner fights the foreclosure, it can take up to a year or longer. One is because there's just so much involved in it. And then 2, it's in district court. District court seems to move a little more slowly. You have to serve everyone with an interest in the property. So in the collection action, we are just going after the owner or owners. The foreclosure action, you have to serve the documents to the other lien holders. If there's a creditor that got a judgment, even if it's the neighbor who sued him and got a judgment and recorded a lien against the property, anyone who has an interest in the property. If you cannot serve them, you have to publish the notice, and that is required to be in the paper for a number of weeks. You have to then get judgment from the court. We then have to go to the sheriff's sale. It has to be advertised with the sheriff for 5 weeks, and the sale has to be at least 4 months out, 120 days. So it takes a long time. The benefit of it is that it solves a lot of problems, but it's a lengthy process. So here's some of what happens with the foreclosure. So regardless of whether the foreclosure comes internally from our office, so let's say the collection action where I say, hey, look at this, and the board decides to foreclose, or it's going to come from you all saying our board wants to foreclose. The foreclosure is going to obtain what's called a litigation guarantee. It's the title report, and what they're looking at is what other liens and encumbrances are on the property. Who owns the property? Did we notify the correct owners? Have they gone through the collection policy? All of that, or the collection process, all of that that we've talked about beforehand. They're then going to file the complaint and again serve it to any party that has an interest in the property, so whose name is on the property in some fashion, or a lien against the property. Then, depending on who those people are, there might be stipulations. That's a court, an agreement that's filed with the court that says we're going to stipulate to lien priority. What does that mean? Let's say there's two associations for the same property. You're going to want to stipulate or agree that both association is treated equally, gets the same amount back. Their liens aren't going to be wiped off of it, versus other lenders that maybe are over us or under us being the association. There's a super lien. That's the equivalent of the 6 months worth of assessments that came due prior to the foreclosure being filed. Then again, default judgment, great, but if there's an answer filed, that's contested. Assuming finally you get the order for foreclosure entered, you have to take the order to the sheriff in that county. There's the publishing in the newspaper. There's what's called a cure statement. So at least 15 days before the sheriff's sale, the owner can come in and say, hey, I'd like a cure statement. I'd like to know what it would take to keep this property. What do I owe? If the owner pays it, great. The sale can be canceled if it's paid in full. If the owner doesn't, it's going to go to sale. And then once we get to that part of it, the highest bidder at the sale is going to obtain the certificate of purchase, but then we have what's called redemption periods. Each redemption period is for each lien holder that has lien against property, and each period is 8 days. So that's going to keep pushing us down and down and down until the process is wrapped up. It could take a while. Generally, we're hoping that the investor steps in, unless the association wants to keep the property, that the investor steps in and purchases it, because we have a lot of investors, particularly in Colorado, that buy the property. They'll then kind of upkeep it and then turn around and sell it. So common outcomes. 1, the homeowner pays it off, foreclosure is stopped. 2, the investor purchases it at sale. Great. Then it's the investor's problem. The association still has now whatever lien it may have from the new owner of the property, but at least that past owner, the past due balance is taken care of. 3, the association can become the owner, and then 4, nothing happens. It's canceled for some reason. If the association becomes the owner, the most common question we get is, does that mean the association has to pay off the mortgage? No, it doesn't have to pay the mortgage on a monthly basis. If the association becomes the owner, it can either sell the property, thereby paying off that mortgage, because the association's foreclosure does not strip off the mortgage for the mortgage on the home. So it could sell the property outright, pay off the mortgage, property goes to someone else, association's done, and goes back to being an association. It can rent the unit out temporarily until the mortgage decides to foreclose. So it'd almost be like a receivership without a receiver, where the association says, great, we're the owner right now, let's just get some rental income in, and we'll just wait for the first mortgage to foreclose. They can refinance, again, paying off the mortgage, and then keeping the property long-term. However, if the association decides to keep the property long-term, the association, as the owner, is now responsible for the upkeep, the assessments, the maintenance, etc. So all discussions that you would have, the association would have with the foreclosure department as to what ultimately its goal would be. So that is all I have. I'm going to go through some of the questions. Certainly, if you have other questions, let me know. So one of the questions is, are there mitigating circumstances that mediation should be rescheduled, things beyond the homeowner's control? There are. So right now I want to say all counties. I certainly haven't had one that has gone back to in-person for mediation. But in the majority of the counties, mediation has been virtual. That doesn't mean things don't come up. Certainly, if we have an owner who we get this a lot, and it's not bad. We have owners who came down with COVID and can't do mediation, or the mediator who was sick and we had to reschedule mediation, or there's a death in the family, or a number of circumstances. And so generally, I recommend if there's just one request to reschedule, I'd recommend the association say, sure, that's fine. Again, as long as we're in those deadlines that the court has set. If we have an owner who repeatedly requests to reschedule mediation, then you start to know, like, hey, look, you're kind of just putting this off. Plus, we run up against court deadlines because the court is going to issue an order saying you have to have mediation completed by a certain date. So can it be rescheduled? Yes. Is it rescheduled? Yes. Should it always be rescheduled? No. Next one. Have you seen cases where a lender becomes aware of a foreclosure initiated by an HOA and they step in to pay the outstanding balance? And if so, how does the lender become aware of the foreclosure? Yes. So the lender usually, the first mortgage sometimes will pay it off just because they don't want to have to deal with it. But a lot of times we'll see a subordinate lien holder, a junior lien holder come in, like a second mortgage, and say, hey, we just want to pay it off because then they don't have to worry about our foreclosing over them. They're aware of the foreclosure because, again, if they have any interest in the property as a lien holder or a lender, because a lender would have a lien against property, they would be notified in that through service of process in that foreclosure action. And then Raven, I have an association with 2 foreclosures in process. They're concerned it is inevitable they will have to be responsible for paying off the existing mortgage balance for both out of pocket before seeing any funds back from the debt owed. Does it go to sell prior to the association having to pay off the mortgage? So the association does not have to pay off the mortgage. It's the contract of the mortgage is between the owner and the mortgage with the property as collateral. The association, if it wants to keep the property in general after the sale, so it goes to sale, the association ends up being the highest bidder and no one else comes to purchase the property. The association would then have to make the decision whether it wanted to keep the property, and it would need to refinance to get a mortgage in its name and pay off the prior mortgage, or sell the property to someone else and then sell it for enough that it paid off that senior mortgage. Hopefully that answers your question. The short answer is no, it's not really correct. Covenant enforcement process for homes in bankruptcy or foreclosure. So it's a property in bad need of paint. They were in bankruptcy. In that case, is there really nothing the HOA can do to get the home painted? Kind of. So the bankruptcy, what the bankruptcy does is just puts a stay on collection. So if collection or any actions in the furtherance of a collection. So if you're looking at fining the owner or filing liens against the property, then we're going to run into an issue with the bankruptcy because of that automatic stay. The association can request permission from the bankruptcy court to obtain what's called relief from the stay. So basically a motion, which is the paper submitted to the court saying, hey, judge, we want you to look at something. Saying, judge, we want to be able to proceed with this property because the owner's not keeping up with it. However, depending on the fine situation and the painting, I mean, really the simpler issue would be to work with our covenant enforcement department to have them working with the owner or the owner's attorney to get the house painted without having the issue of the fines and the liens against the property. Raven, you should call me, or Kate. You should call Kate. If no one else thinks, if no one else showed up to purchase the property, right? So if no one else, if your property's in foreclosure and no one else bids on the property, the association is going to end up the certificate of purchase holder, the COP holder, which means the association is the official owner. Again, though, that doesn't obligate the association to pay the mortgage, because that's a contract between the mortgage, the lien holder, and the owner. The association would only have to worry about the mortgage if it decided it wanted to keep the property long term, and then it'd want to refinance. So the foreclosure, when you're welcome. When you're foreclosing, in order to bring the foreclosure, you have to have at least 6 months worth of assessments. So the foreclosure is going to collect all of the balance due on the account, or attempt to. When a foreclosure is filed and that balance is submitted and the cure statement and the bid, that's all going to be the total owed. So assessments, late fines, interest, attorney fees, the foreclosure attorney fees, costs, all of that. When you're first looking at the foreclosure, though, and you're going to vote on it, our foreclosure department's going to look and say, are there at least 6 months worth of assessments on that journal or on that ledger? What does that mean? It means, let's say there's $3,000 on the ledger, but it turns out the owner's only been delinquent on assessments for 3 months. Even though we could foreclose and collect that entire balance, we can't move forward with a foreclosure until there's at least 6 months of assessments on there. It's just to keep associations, or in this case associations, but from coming in and just saying, well, they've missed one assessment, let's foreclose. So there has to be at least 6 delinquent assessments on there, the equivalent of it. But we're going to collect the whole thing, or attempt to collect the whole thing through the foreclosure. I don't know if there's any other questions on here. Certainly send them my way. You can get contact information on the website. You can also see, certainly any of us in the collection department are more than happy to help you. Covenant, Jeff Smith and Deb Oppenheimer, and then Kate Leeson, who is in our foreclosure department. Thanks everyone for coming. I have one more question. If an HOA has not had a zero balance, a homeowner, sorry, has not had a zero balance for years but have a negative balance, is that acceptable? Yeah, that's fine too. So if they paid it off to the point that there was a credit on the account, for intents purposes, that's going to be a zero balance. If the association only pays twice a year, how does that work? I'm assuming you mean for the foreclosure. So if it's the equivalent of 6 months worth of assessments and it's semi-annual assessments, then we will probably look at it after that second assessment hits, because that would be roughly a breakdown of 6 months, even though they're due semi-annually. However, you'll want to talk to the foreclosure department, because they might look at the amount and say, you know what, it's better if you push it off a little bit anyway. All right, so I've kept us over a little bit. It's 1:03. I hope you all have a great day. Be safe. Enjoy the weather. Bye.